Good afternoon, everyone. I'd like to welcome you all to today's seminar, A Common Sense Approach to Estate Planning. My name is Steve Auger, and I'm Assistant Vice President for Major and Planned Giving at Sacred Heart University. Our seminar today is going to be in a question and answer format. So please use the chat box if you have questions, and you can participate in the seminar through the chat box. We can't obviously answer and talk about specific situations, but if you have or provide legal advice, but if you have more general questions, be more than happy to provide guidance. This seminar is also being recorded so that you can come to this later. You'll be provided with a link and you'll be able to share it with friends, family, and again, watch it again in case you have questions later. In my work at the university, I interact with many alumni who are thinking about estate planning, and they're looking ways to support the university through their estate plans. Whether it's Sacred Heart or it's the local food bank or the animal shelter or your local parish, it's something I strongly recommend that people take a look at. It's a gift that you don't necessarily need to lay anything out of your pocket right now and can have a great deal of impact in the future. The second group that I usually work with are people who have general questions. You know, how do I make sure that my loved ones are protected? How do I deal with this asset in my estate? How do I avoid taxes on my estate and as I'm planning my future out? And I hope we can answer some of those questions for you through our seminar today. Our speaker today is Matt Reale. Matt is a great friend of Sacred Heart. He's also a 1986 alum. He graduated from Villanova University Law School in 1989, and he's practiced in Philadelphia and now is in private practice up in Shelton at Anthony and Reale. Would practice that he opened in 1992. And over the past 24 years, Matt has focused his practice on real estate, probate administration, estate planning, workers' comp, personal injury, labor arbitration, and the general practice of law. He's admitted to the state of Connecticut and Commonwealth of Pennsylvania bars. He's admitted to practice before the United States Federal District Court and for the District of Connecticut and the Eastern District of Pennsylvania and the United States Supreme Court. He is a member of the Connecticut Bar Association, Valley Bar Association, and Greater Bridgeport Bar Association. He serves on the board of directors for the Bridgeport Bar Association and is chairman of the Real Estate Committee. So with that introduction, welcome, Matt.
Hey, thank you, Steve. I appreciate the nice comments and the review of my resume. You didn't have to repeat the years that I graduated Sacred Heart for law school. I like to think those were closer than they are further away. It's my pleasure to be here today. Hopefully some of the information that we provide on this Zoom call seminar is helpful to the people who are viewing. I'm happy to assist, happy to have the opportunity to give back to the university in a small way, to the in some reply to the amount of time that they've given to me and benefit that Sacred Heart's provided to me and my family. So I'm happy to be involved.
Okay, let's start. Let me ask you, what's the goal of estate planning? We talk a lot about, you know, planning for the future. What is the goal when someone comes to your office? What are you looking to do and what are they looking to do?
That's a very good question, and it's a very open-ended question. Anytime you're talking about estate planning or planning of your final affairs, as far as administering your assets or making certain appointments of people to handle your affairs, such as maybe being a trust for money left for minor children, or even to raise your children. God forbid something happens to you when your children are still of a very young age. All those factors come into play. So to ask the question about estate planning, really you need to be somewhat introspective and look at yourself first and think about where you are in your life, what station of life you're in, how's your health, how's your wealth, and what's your family situation. Those are the general topics that I try and extract from people and ask questions of them to find out what their intentions are. Because any type of estate planning, the foundation of that is determining what the intention of the person making those plans would be.
So we talk about estate planning, and usually when you talk about it, there's people look at this. It's for the gray hairs like me. When should people start looking at estate planning and planning their future?
There's a variety of answers to that question, but typically from my point of view and my experience, usually when somebody buys a house, they're a younger family, they're purchasing a house, their thought process is, ooh, I have a house, I have young kids, I need to do something to protect those assets that I have and to provide for my family. So that's generally the initial contact that I make with some people at that very young age or at the beginning stages of their life as a family. And then next, the second step is I usually get phone calls from people when they're thinking about retirement or pre-retirement. They have accumulated wealth, their children have left the house, have graduated college, are starting their lives. So the people are starting to plan for their own lives as opposed to providing for their children. And then lastly, the third stage, so to speak, is when people are considering, geez, I need to protect my wealth significantly in the event that there's some tragedy to me and I end up in a nursing home. Those are some of the issues that really raise the flag of maybe I should do some estate planning and talk to somebody about what to do about my final plans.
Yeah, estate planning is kind of a broad topic. It's kind of a broad area. What are the critical pieces? I mean, everybody knows, well, estate planning, we're talking about a will, but what else is involved in that?
So generally speaking, the trilogy of estate planning is basically a will, a living will, and power of attorney. Those are really the three operative documents. There's some other documents that stem from those three, but typically a will is basically a statement of someone's intentions upon their death. That's all it is. Just as it says, last will and testament. Testament meaning speaking about what my intentions are after my death. So it's a statement of someone's intentions upon their death. And those intentions can be how to distribute property and making certain appointments or provisions for the care of minor children or for the management of assets left for minor children. So that's what a will is. A living will, by definition, living, meaning that it's a statement of your intentions during your lifetime. And that statement of intention is, what's my plan or what are my intentions with regard to the use of extraordinary life support measures to sustain my life in the event that my doctor makes the determination that I'm permanently unconscious, in a vegetative state, and my condition is terminal, meaning that it's going to lead to my death. So the intention would be, if the doctor makes those determinations, then my intention set forth in my living will would be, I don't want extraordinary life support measures to be used to sustain my life. And those extraordinary life support measures are things such as artificial means of making you breathe. So you can't breathe on your own, you're using a machine or a respirator to make you breathe. Same thing with regard to your heart beating, artificial means of making your heart beat, and artificial means of ingesting food and ingesting hydration or water. So it's a statement of your intention during your lifetime that you don't want those extraordinary life support measures to be used to sustain your life. Lastly is the power of attorney. And it's not for everybody, but a power of attorney is a very useful tool to plan in the event that you're unable to do things on your own, Or just as a matter of convenience, you want to appoint a third party to serve as your agent to do things on your behalf. However, I will add this caution that if you're thinking about executing a power of attorney, you really want to understand the specifics of that power of attorney, the specific authority that it provides to a third party, because there's limitations you could put on a power of attorney. However, if you do not put any limitations on that power of attorney is a very powerful tool for the agent. So you want to make sure you understand its power and its authority that it's granting to a third party.
Okay. You were talking about a living will. Is that the same as advance directives?
Yes, it's very similar. They're synonymous. And I'll give you this example.
Right.
If you are going into a hospital, because the living will in the state of Connecticut basically does three things. One, it provides the provision that I talked about with regard to extraordinary life support measures. Number two is it appoints a healthcare agent to make healthcare decisions for you if you're unable to do so. And then number three is it makes a proposed appointment of a conservator, in other words, a person who can act on your behalf if you're deemed incompetent. So the distinction between advanced directives and the living will portion, meaning the withholding of life support, is this. When you go into a hospital for elective surgery, so you know you're going in for surgery on a certain date, well, the hospital will have you come in, or the doctor's office will have you come in, and they'll go through a certain degree of orientation or pre-operation procedures. And as part of those pre-operation procedures, the doctor will ask you if you have signed advance directives, if you have a healthcare agent, and if you don't, they'll ask you to make those representations at that time. A living will really handles that emergency type situation. If you get into an accident and it happens to be a catastrophic accident, it serves as your intentions in an emergency type situation. So that's the distinction sometimes between advance directives, which hospitals very commonly will have somebody review and sign, as opposed to a living will where you would do something in advance in the anticipation of an emergency type or exigent type circumstance.
Okay. You hear a lot about a living trust. Now, what is a trust and how is it used in estate planning?
So a trust, once again, there's no specific answer for a trust. I can tell you that a trust is an entity that's created as a third-party entity, separate from the individual, where you can transfer assets into for a variety of reasons. One is maybe to protect it from creditors. Two is, depending on the type of trust, to protect it against Title 19, preserving assets. The term living trust basically comes from the distinction between the two general types of trusts, and that means when they're created. So a type of the two distinctions are what's called a testamentary trust, which means a trust that's created within your will, is a trust that's created after you die. The other type of will is what's called an inter vivos trust. So a trust created during your lifetime. And that's the vernacular that's morphed into the term living trust, because it's a trust that's created during your lifetime. An example of a testamentary trust would be if I have a will and when I die, I leave everything to my wife. And if my wife predeceases me, then I leave everything to my minor children. But my minor children, I want their money to be managed by a third party because they're minors. So in my will, I would provide that any monies going to my minor children or children under a certain age, you can set your own age limits, 21, 25, 30, depending on what your area of comfort is, then I would appoint a trustee to manage that money, and that trust would be created after my death as part of my will, and that's why it's called a testamentary trust. The other trust is, like I said earlier, what's called an inter vivos trust. So it's a trust created during your lifetime. An example of why you would create an inter vivos trust would be, sometimes people call it avoiding probate. So you would create this third-party entity called a trust, and then you would fund that trust with your assets. And that trust would have the terms of how you can use your assets during your lifetime as the creator of the trust. But then it also would make a provision with regard to if you die, what happens to the assets of the trust. So for example, you fund the trust by transferring your assets into the trust. And if you die, your trust can provide that everything goes to my children in equal shares or my surviving spouse. So the term living trust really relates to the fact that it's a trust created during someone's lifetime as opposed to upon their death, which is referred to as a testamentary trust.
Okay. You mentioned before about powers of attorney. Is a power of attorney one size fits all? Does everybody accept it, or are there different types in different situations?
Good point. Power of attorney is not a one size fits all type document. However, by statute, there's a form that the state of Connecticut has approved to use as what's called the statutory form power of attorney. And that power of attorney enumerates or lists all the powers granted to the agent. So think of it this way. If you're creating a power of attorney, you're the principal and you're appointing another person to act as your agent. And that other person, called an agent, has the authority to do whatever you have the authority to do as soon as it becomes effective. And it becomes effective upon your delivery to the agent. So it's very important to be aware of the specific power of attorney you may be signing, because it grants authority of a third party to act on your own behalf. An example of limiting that power would be in a real estate transaction, for example, if husband and wife are, let's just say, buying a house and one of the spouses is unable to come to the closing to sign, a bank may allow that spouse to sign power of attorney to the spouse who's attending the closing to sign on their behalf. And that bank would require a specific form, and they would generally require a specific power of attorney solely for the power to sign for the mortgage papers relating to a specific piece of property. So once the transaction is completed, then there'll be an expiration on that power of attorney. So that's a way you can limit the authority granted to a third party. But I can't caution people enough to really be in tune to what you are signing. If somebody asks you or requires you to sign a power of attorney, make sure you understand the authority that you're granting to a third party, because that authority may come without restrictions.
Yeah, that's a really good point. When we talk about estate planning, I think most people think, well, everything that I own, everything that my name is on is in my estate. But what is an estate? What assets are in an estate? What are not in an estate?
Okay, so in order to answer that question, let me tell you a little bit about probate administration. So probate administration is when somebody dies. Basically, the state of Connecticut has district courts set up within each town or general geographic region surrounding the town. So for example, the town of Stratford has its own geographic region. The town of Shelton has its own geographic region. The city of Bridgeport has its own geographic region. However, the town of Trumbull encompasses Trumbull, Monroe, and Easton. So it's really geographic regions. Many of the regions are single town, other have multiple towns to just encompass a certain district. So the courts are set up to administer the assets of a decedent upon their death, a decedent being the term for somebody who died. And the court has authority over or jurisdiction over any assets owned individually or solely by a decedent at the time of their death. And that's really important to understanding the probate process, but also understanding estate planning, because any assets that are owned jointly, meaning with another person, automatically pass to that surviving joint owner without having to go through probate. So it's quite common when someone comes into my office and we talk about the nature of their assets and how they're owned, that when they talk about, oh, well, I left all my assets through my will and it's all going to go to my sister. And I asked them, well, what assets are you talking about? And they list maybe a house that they own in their name individually, and an automobile that they own in their name individually, and a checking account that they own in their name individually. And then they said, oh, yes, but I also have this other account that I own with my brother. But that's going to go to my sister also. And it's a very good way to explain to them how that asset does not go to their sister because it's not solely owned. It goes to the surviving joint owner in my example, which was the brother. Even though their intention and in their will was everything goes to their sister. The term everything in my example is only those items that are solely owned or individually owned by a decedent at the time of their death. So it's really important to understand as part of the estate process, not only what you own, what assets you have, but how title is held to those assets.
What about something like a life insurance policy or a stock account where you've made someone the beneficiary of that? Does that fall into an estate, or is that something that falls outside the estate?
That's another good question. And by example, that's a way of estate planning without officially planning, right? Because by virtue of naming a beneficiary on a life insurance policy or a life insurance contract, you've effectively taken an asset and you're able to pass it outside of your will. So it passes directly to the beneficiary named in your life insurance policy. The same thing with retirement accounts like a 401k or an IRA, what are referred to as qualified retirement plans. You have the opportunity to name a beneficiary on those plans. So when you pass, those plans by operation of law automatically pass to the beneficiary, provided that there's a named beneficiary. So as part of the estate planning process, individuals can do their own planning by naming joint owners on property. So if you're husband and wife and your intention is that if something happens to you, everything goes to your surviving spouse, well, there's a way that you can manage that without having to prepare a will. And that is just making sure all of your assets are owned jointly. And then also you can add a beneficiary to your life insurance contract. Make sure there's a beneficiary in your life insurance contract and an alternate beneficiary. God forbid something happens to you and the beneficiary, you want to provide for an alternate as well. And the same thing with your retirement plans. And stock accounts. Some stock accounts allow you to either own it jointly or to name a beneficiary in a stock managed account as well. And then lastly, some banks allow individuals to create bank accounts that are transferable or payable upon death, sometimes referred to TOD, transfer on death account, or POD, payable on death accounts. And those accounts pass automatically by operation of law to that third party you may name in that bank account.
So what would happen in the case now, and I have seen this before, I'm sure you have too, where a husband names the wife as the beneficiary of an account. The wife predeceases the husband, but he never changes the beneficiary. What happens in situations like that?
I've seen one of two things happen, and it depends on the plan administrator. I've seen some plan administrators, what they do is it automatically inures to the children if they're surviving children of that individual. Others, I see that because no beneficiary is named, it now becomes part of the probate estate. And so it's treated as an individually owned property. So for example, if you had a life insurance contract for $100,000 and your spouse was named as the beneficiary, your spouse predeceases you, you pass, that $100,000, instead of going directly to a beneficiary, now becomes part of your estate and is subject to probate administration. The importance of avoiding probate administration is that you avoid that $100,000 in my example from being subject to any creditors or any people you owe money to at the time of your death. So if you died owning jointly owned property, and you had significant debt, no estate gets opened all that property passes to the surviving joint owner and a creditor goes unsatisfied. So that's the importance of avoiding probate with regard to protecting or preserving assets from creditors, for example.
Great, great. Now, I'm looking to do estate planning, and I'm coming to your office to talk about my estate and the documents you spoke about. How do I prepare for the visit? What do I get? What do I bring for my visit with you?
Sure. Good question. And, depending on each individual, I basically ask people to have an understanding of their family situation, right? Because I need to know if you married, children, blended marriage, children from a prior marriage, things of that nature, right? Your wealth, what you own, and how you own it. Once again, not only what, but how you own it, whether it's owned individually or whether it's owned with another party jointly. And then also your health situation, because it's very important in estate planning to understand somebody's health situation. If somebody has some significant health issues, the planning is going to be a lot different than somebody who is planning for a long life to live ahead of them, as opposed to somebody who knows because of their health problems that they may have a shorter lifespan. So those are the type of issues that are really important. Your finances, what you own and how you own it, your family situation, and your health situation. So I generally ask people to bring in a brief inventory of what they own, how they own it, and a ballpark value. And the ballpark value helps me to assess whether or not there's going to be tax implications as a result of somebody passing.
Right, right. So that's what people need to bring you. What should people be telling you? You covered the health, but what else should they be telling you in your visits for you to consider when putting together their plan?
Well, in a conversational way, I very rarely will ever prepare a will for somebody without having met with them and discuss their situation, because everybody's situation is unique. There's some attorneys or planners out there, and by nature of the pandemic, it's difficult to meet face to face with people, even though through Zoom we can accomplish a reasonable substitute. However, I like to meet with someone personally and sit across the desk and ask questions about who they are, why they came to the revelation that they needed to create an estate plan or wanted to draft a will. Find out where they are in their station in life, and just ask questions and get to know a person, and then direct them down the path of, well, what are your intentions? It's not the responsibility of the estate planning attorney to tell someone what their intentions are. In my opinion, it's the intention it's the responsibility of an estate planning attorney to obtain the information from a person and then ask them what their intentions are and help them come up with a plan to effectuate those intentions to best satisfy their needs and their intentions.
Can you talk a little bit about the importance of communication, within the family? And, how should somebody who's doing their estate planning, how should they talk about that with their family? What should they tell their family about their assets and their intentions?
So there's no specific answer to that question. However, it all relates to what's reasonable and what's reasonable under these circumstances. And, for example, if you have a husband and wife and they have two small children who are 3 and 5 years old, and they want to create a will, and they want to really provide for what happens to our children if something happens to us. Who's going to take care of our children? Who's going to be appointed to manage any money we leave for our children? Those are the type of issues that come up with a very young family, right? I would never recommend to somebody to sit down their 3 and 5 year old and say, okay, little Johnny and little Sally, when mommy and daddy die, here's what's going to happen to you guys. Here's who's going to take care of you, and here's the money that's left for you. Here's who's going to manage that money, right? That wouldn't be reasonable, in my opinion. However, if you have, older children who are mature and understand, that at some point you're going to pass, it's very important to have that communicate what your intentions are to your children. And it's helpful because then there's no surprise at the end, right? We all know we're going to die at some point. It's not a matter of if you're going to die, right? It's a matter of when. So planning for it, number one, is very important. And having a frank discussion with your family members is important as well. However, it needs to be tailored towards your station in life. As parents get older, and I'll use my mother as an example. My mother's 90. I'm not going to tell you how old she is, but she's old. So, she determined it was very important for her to sit down and, as a family, and her tell us what she owned, how she owned it, where her will was, what her final affairs, what she wants for her final affairs, things of that nature. So now we understand what her intentions are, and we're better able to effectuate those intentions. I know sometimes in my practice, somebody asks me, well, I want to be cremated. So I'm going to put that in my will, because if I put it in my will, those are my intentions, and my intentions will get followed because it's in my will that I want to be cremated. Well, you asked about communication. It's important for your final affairs, something that what's going to happen to your remains, your body, that you let someone know that outside of your will. Because oftentimes the will doesn't get read for weeks after, or doesn't get found for weeks after somebody passes. So it's very difficult to, handle someone's final affairs if they wanted to not be cremated and you made the decision to cremate them, and then subsequently you find out in the will that their intentions were they did not want to be cremated. Well, that's a little hard to reconcile that difference, right? So it's very important to communicate final affairs to your family members, and communicate it reasonably. And when I say reasonably, I mean based upon the circumstances. So you're not explaining to a 3 or 5 or a 7-year-old, when somebody passes, what happens to their property. But you need to assess each situation and communicate reasonably with your family members, so people's expectations are known.
I think we have a good question in the chat box. Can you discuss the difference between revocable and irrevocable trusts?
Sure. Revocable and irrevocable trusts are, a revocable trust is a trust that you can change. So it's like the hokey pokey. You can put some money in, you can take some money out. You can put some money in, you can take some money out. Irrevocable trust is, once you set the trust, it's set it and forget it. You cannot change the trust. So once you put money in, unless the terms allow you to take money out, you cannot terminate that trust. By definition, it's non-revocable. There's certain reasons why you would use a revocable trust over an irrevocable or non-revocable trust. And those reasons sometimes relate to Title 19 planning, which is the state subsidized long-term medical care. So when you put money away, it's an actual gift. So you put it in an irrevocable trust, you can't take that gift back. There's a lot of issues that spring off of that discussion, but that's generally the distinction between a revocable trust, so a trust that can be changed, and an irrevocable trust, a trust that cannot be changed.
How does estate planning factor into when you're working with someone? How does it factor into that Title 19? I think you mentioned.
Yeah, so it's asset preservation. Title 19 is if you go into a skilled long-term care facility, right, and you have money, you're required to self-pay or pay for that care on a monthly basis, which could be anywhere between $11,000 and $15,000 a month, until you spend that money down to zero, and then Title 19 would pay for your care. So what people try to do in anticipation of if that ever happens to them, they try and preserve their assets. So if they have to apply for Title 19 because they're required to go into a skilled nursing facility, then they try and make sure that they've gifted away their assets or put their assets in a trust that's non-revocable. So it's not part of the Title 19 application for the purposes of determining somebody's assets. It's a pretty complicated process to go through, and it really is a separate entity in and of itself, and that is Title 19 planning. As somebody gets older, if they have a certain degree of wealth, you really want to sit down and talk about those specific issues about the what if. What if there's a possibility you're going to be required by your doctor to require skilled nursing facility care?
What is the look back period that they use for that?
So right now, I believe it's 5 years, but that's subject to change. And what that means, the look back period, is if I gifted money today, when I apply for Title 19, generally they'll ask the question of list all your assets, and then list any assets that you've gifted away or delivered to somebody for less than fair market value in the last 5-year period. And when the state assesses that Title 19 application, they basically go through a forensic accounting to determine whether or not any assets were gifted away to a third party. So it's not as easy as, hey, I didn't give anything away. You have to provide the bank accounts and statements, and they do a forensic accounting to determine whether or not those assets are part of the Title 19 estate or not.
Going back to the trust question, what are the tax implications of setting those up?
So from a tax point of view, you definitely want to consult an accountant, because when you transfer property to a third party for less than fair market value, when I say a third party, not only gifting to your children, for example, but gifting or transferring to the trust, there may be some gift tax implications. The state of Connecticut and federal government has a gift tax. So when you give property to another or gift property to another for less than fair market value, there may be a tax consequence. Although there are some exceptions and there are some ways to utilize your estate planning tools to mitigate the tax consequence of making a gift. So for example, you can gift up to $15,000 exempt from gift tax to an individual in any given year. So if you have 3 children, you can gift up to, $15,000 each or $45,000 tax-free. But you should, if you're going to be creating a trust, not only consult a lawyer with regard to the mechanics of setting up the trust and the reason and the purpose for setting up that trust, but also you should consult with an accountant with regard to any tax ramifications of funding that trust. Funding that trust meaning transferring assets from you individually into that third-party entity known as a trust, because it's two separate entities. You, the individual, versus the trust that you created on your behalf. But you should consult not only a lawyer, but an accountant as well, because there's a certain tax consequence. There may be a certain tax consequence or impact as a result of transferring property from you as an individual to a trust you may have created on your behalf. And once you create a trust, depending on the type of trust, there may be tax filings required on an annual basis. So for example, if you create a trust and you fund that trust and that trust is earning income, you're going to be required to apply for a tax ID number for that trust. So a tax ID number is basically a social security number for a trust. And the reason why we have social security numbers is not in case we forget our names, right? No, it's so the government can track and make sure that they have a number to associate with somebody paying taxes. And that's the whole purpose of a tax identification number for a trust. It creates a obligation for that trust to submit tax returns on an annual basis. And that's the importance of having a good accountant who understands trusts and who understands gifting as well.
Another question in the chat box, what are the fees to create a trust?
Yeah, that's a difficult question to answer because there's many different trusts. What I would suggest is that whoever you consult with regard to creating a trust, you find out that a trust is necessary for you. I mean, unfortunately, we live in a world where, media kind of dictates people's expectations. And I've seen, the full page ad in the newspaper or on TV saying, come to our living trust seminar, learn how to avoid probate. And it's almost like a scare tactic, like probate is this really bad place to be, where really it isn't for most people. and they prey upon people's concerns that, for example, in the state of Connecticut, there's a death tax. That's what they want you to believe. Oh my God, there's a death tax in the state of Connecticut. I've got to avoid probate so I don't pay that death tax. That's not necessarily 100% true. There's also an exemption in the state of Connecticut. In 2022, we're exempt up to $9.1 million. And in 2023, I think it's going to go up to 12 or $14 million. So you can be exempt up to that amount of money. Very few estates are subject to death tax. So even if you created a trust and put all your property in that trust, and that costs you $5,000 to do that, depending on your degree of wealth, if it's below that exemption level, you're still going to have to at least file a death tax return with the probate court if you have any real property to get a lien release for that real property. So there's still some kind of fee that's going to have to be paid to the probate court. And it's probably less than the $5,000 that you paid to create the trust and get the nice shiny binder that said you have a trust. So I would just be very careful with blindly saying, I need a trust. I would have an inventory of my assets, and I would sit down with somebody who knows what they're doing with regard to estate planning, and then ask them whether a trust is necessary for you based upon your particular circumstances, those being, once again, your finances, your family, and your health.
Well, we've talked a couple of times about probate. Can you define what probate is? I mean, it's you say it's not a scary term, but that's what a lot of what we do is trying to avoid probate. So can you walk us through what probate actually is and what it does?
Sure. So the probate court is set up to administer somebody's affairs after they die. An estate basically is the creation of that entity after someone passes. And basically the process is collecting all the assets owned individually of a decedent at the time of death, paying any just debts or valid debts of the decedent at the time of their death, paying any administration fees, which would be, for example, the probate court fee, funeral expense, and then whatever's left over, distributing it to the beneficiaries if somebody died with a will and named beneficiaries, or through what are called the laws of intestacy, distributing it to surviving heirs. But that's really the probate process. Collecting assets owned individually by the decedent at the time of death, paying any debts or expenses, and then whatever's left over gets distributed to heirs or beneficiaries, depending on whether somebody died with a will and the property would pass to the beneficiaries named in the will, or if somebody died without a will, it would pass to their heirs as under what are called the laws of intestacy, which is the state statute that dictates how your property gets distributed to your relatives upon your death if you did not prepare a will.
What's the time frame for an estate with a will to go through probate?
So typically, there's a 180-day creditor claim period. So usually between 6 months and a year. But once again, it all depends on each particular estate with regard to the type of property that's owned, collecting assets, what kind of debt is associated with the estate, whether there's any individuals who are claiming that maybe the will's not valid, so maybe a will contest. But typically between 6 and 12 months should be resolved in full.
Excellent. Okay. We talked a little bit about taxes, and you mentioned the exemptions being very high. And then on the federal level, it's 22 million, I think. On the state level, it's going to be 12 million. Are there taxes that people really need to worry about?
Most people do not need to worry about death taxes or inheritance taxes. I think sometimes people confuse that with what's called the statutory probate fee. So for example, if somebody dies with a house worth $500,000, whether it's individually owned or jointly owned, it's real estate. And that in the state of Connecticut, because we have a death tax, the state of Connecticut has an automatic lien against any real estate owned by somebody either individually, jointly, or in a trust when that person dies. And they're required to make a filing with the probate court for the purposes of demonstrating that they're below the $9.1 million death tax exemption. And then based upon the value of that asset or the value of that decedent's interest in that asset. So in my example of $500,000 valued real estate, if somebody owns it with their spouse, it would be 250 would be attributable to the estate. And the statutory probate fee would be based upon that $250,000, and it'd probably be approximately $400 or $500. So the statutory probate fee is not prohibitive. It's just based upon the value of your gross taxable estate, and that gross taxable estate is determined by the assets you own individually, jointly, and those passing outside of probate as well.
Right. Another question in the chat box. If you own something jointly, do you have to pay probate on your half of the asset, for example, a bank account?
Yes. Yes. So when someone dies in the state of Connecticut, if they're required to file anything with probate court, even if it's what's called a tax purposes only estate, where you're not actually opening up an estate, but if you own real estate and it's owned jointly with another person, or a bank account that's jointly with another person, the what's called 706 tax return provides for basically three parts. The first section is any solely owned property. So even if there was no solely owned property, the second section provides for any jointly owned assets. And you would list the jointly owned asset, like my example before, 123 Main Street, owned jointly with my spouse, worth $500,000. The amount attributable to the estate would be $250,000. If I had a joint bank account with my spouse and I had $10,000 in it, that would be $5,000 would be attributable to the estate. And then you also, believe it or not, need to list any retirement accounts that are passing outside of probate and life insurance that's passing outside of probate. Even though probate doesn't have jurisdiction over those assets, they're reportable for informational purposes and for purposes of determining the statutory probate fee. So the answer to the question is yes, you do have to report those assets, especially if there's real estate involved, because of the automatic tax lien on the land records that the state of Connecticut has on any real estate owned by a decedent at the time of their death.
When you have assets in probate, what happens to the assets? Do you have access to them? Does anybody have access to them? Or are they just basically kind of in limbo until the court decides that they can be released?
Good, very good question. And I think it relates back to your initial question of why should I prepare a will? And part of preparing the will is, yes, this is where how I want my assets to be distributed. But also in that will, you make an appointment of somebody to be representative on behalf of your estate, that person called a fiduciary, either an executor if it's a male or executrix if it's a female. And when you submit the will for probate to prove that the will is valid, once the court accepts the will as being valid, meaning that it's been signed properly, then the court will appoint the person who's identified in the will as the representative for the estate. And then as the representative for the estate, they have a fiduciary duty to the estate to collect all the assets, pay all the debts, pay any administrative expenses, and then distribute the property. So they have authority to act on behalf of the decedent after the decedent has passed, after they've been appointed with that authority by the probate court. And then the probate court, they're accountable to the probate court for the collection of the assets, payment of the debt, and then requesting permission to distribute the assets that are left over.
What happens in a case where there is no will and it goes to probate?
So if there is no will, that's called dying intestate. Intestate meaning without a will. And you would apply to the court for the administration of the estate. And as part of that administrative process, the court will appoint a third party to act on behalf of the estate, the same way as if you prepared a will, you can express your intention of who you want that party to be. But in the absence of a will, the court will appoint a third party.
And the assets are basically in limbo until they've tracked down relatives, or they've completed these searches. And then what happens? I mean, they've completed the search, they don't find relatives. What happens?
Well, typically what happens is if somebody dies and there are no relatives, what ends up happening is the court appoints somebody to try and determine the heirs. And typically they'll find heirs. Otherwise, which is unlikely, it would eschew to the state of Connecticut if there are absolutely no heirs after a pretty significant a search for heirs. But it's unlikely that happens. The more important example is when you should prepare a will, because you get to appoint somebody to serve as your representative, as opposed to if you die without a will, the court's going to appoint somebody who may or may not be the person that you wanted appointed to begin with.
Okay. And last question, since we're starting to run up against our limit. Do you always need a will? If a couple has joint possession of assets, do they need to make a will?
It's not required, but it's recommended. And the reason why it's recommended, in my opinion, is it's a catch-all, right? It's a safety net. So what if there are assets that you were not aware of that were owned individually? Well, now when you tried to plan for everything to be owned jointly and you find something that was owned solely, now it gets administered under the laws of intestacy. Preparing a will is not an arduous task. It's not an incredible feat to prepare a will and execute a will. It's one of those things where people put off constantly. And for whatever reason, it's an important part of planning, but people don't plan to do it. I talk to people conversationally and what I recommend to them, or how I ask them to assess situations, is just think of it as planning. You're planning for something that is going to happen. It's inevitable. We're all going to die. That's the secret's out of the bag. We're all going to die, right? And then I ask them, I go, geez, do you go on vacation? Oh, absolutely. We go once a year. I go, where do you go? We go to Aruba. I go, well, when do you go to Aruba? Oh, we go in April. It's the best time to go. I go, why is it the best time to go? The airline prices are low. There's not as many people there. The weather is beautiful. That's the best time to go. I go, so you plan to go on vacation every year, right? You plan when the best time to leave is. You plan when it's going to be the best weather to be there. And you're doing that once a year, but you're not planning to protect your assets, and you're not planning for something that's going to happen eventually, that you spent your whole life earning, protecting money, protecting your children, protecting your family, trying to maintain good health, yet you're not going to plan for what happens if I die. And that sometimes resonates with people. And then, preparing a will is planning for something that's eventually going to happen. And then just if you do prepare a will, it's not one of those things where you set it and forget it. You want to take a look at it maybe every 5 years and determine where you are. The same way as you go to a doctor occasionally, and as we get older, we go to a doctor a lot more often than we used to. And the reason why is you want to do an evaluation or a checkup of where you are, what you have, what your family situation is, and what your health situation is.
Okay. Just very quickly, we've been talking about a will and doing the estate planning. How long does that process take, and what does it cost?
It varies. The question about the trust, how much does it cost to prepare a trust? It varies, but typically it should be between $500 and $1,000 to prepare a will, living will, and a power of attorney, and give some good, practical, sound advice with regard to estate planning. Because even though those are the operative documents, the common sense discussion of how you own assets, naming beneficiaries, things of that nature, that's valuable information as well. But typically, you can get a will done within a couple of weeks.
Wonderful.
If not sooner, if need be.
Okay. Well, Matt, I can't thank you enough for doing this seminar for us. You've been great, and thank you to everybody who participated. We had some good questions, and again, this is being recorded so that you will be able to listen to this later, and let family and friends listen to it by all means. Hopefully we've answered some questions that everybody had, and I hope that you will all watch your emails for our next seminar. I think we're doing one in December on a different estate planning topic. So thank you very much, Matt. Thank you again for your participation, and everybody have a great day.
Thank you. Take care.